Okay, so I'm Beverly, and I'm a lawyer, a criminal defense attorney here in Worcester, and I'm volunteering with National Lawyers Guild. And National Lawyers Guild has taken on the task of defending Occupy movement folks who get arrested. So we're volunteering our services to assist them.
And I'm Maki. I'm a public defender in Boston, and I also volunteer with the Guild.
And we're having meetings to deal with this, and we're having discussions of how to deal with it. And the National Lawyers Guild is very experienced in dealing with representing protesters, because defending protesters is very different frequently than just doing criminal defense, because a lot of the defenses that protesters have are different. And there's different strategies and techniques for trials, for political trials, that involve doing things that you wouldn't necessarily do in a regular criminal case. So we can draw on the resources of the organization. It's a national organization. There's lots of brain power developing motions and doing research and watching how all these cases are unfolding across the country and sharing all that information. It's a really rich and exciting experience for lawyers in the movement.
And I think that the Guild has a unique approach in that their the defense work they do is really inspired and sort of driven and directed by the movement, not vice versa. Because there's a lot of different outcomes someone can want from a criminal trial. Someone could just want to beat the case. Someone could want to get a really good deal so they don't have to go back to court. Or someone could want a public trial where they air grievances and they make it a real political trial. And it's not our job to make that decision. It's the people, the people who have been arrested and the people who make those decisions. But the Guild, I think, is very strong about providing excellent legal representation in a way that respects the wishes and sort of the self-determination of the people that are on the ground getting arrested, and that's why I like to do it.
Yeah, me too. It's a very respectful environment for the protesters. If they want to have a trial and they want to speak out and they want to tell their story and they want to tell a jury why they're doing what they do, the lawyers are trained and committed to providing a respectful, kind of approach that embraces that and allows people to do that. He was charged with trespassing. A couple of people were charged with other things like malicious destruction or disturbing the peace. But generally, people are only being charged with trespassing. They're trespassing on public space. So it's kind of interesting how the police and how the city is interpreting their trespassing laws, because I think the movement people feel that how can you be trespassing if it's public space?
Yeah, I think there's a very legitimate legal question there, because to be trespassing, you have to be on property without a legal right, and I think that there's a pretty strong argument that when you're on public property, you have a legal right to be there.
And if you're on the public property exercising your First Amendment rights, you kind of even have more reason to be there. So we're kind of confused about how they're interpreting their laws. There were like 16 people arraigned, which means basically it's the first day in court where their charges are announced. And so of those people, I think 4 or 5 have decided that they want to fight their cases and they want to take it to trial. The rest of them accepted deals that were offered to them by the state. So a couple of them agreed to be on probation and do some community service. And most of them agreed to pay a fine, and the city agreed, or the state agreed to reduce it down to a civil infraction so it wouldn't appear on their criminal records. So most of the folks opted for that deal because they said, we want to go back out this weekend and we might get arrested again. So if we dispose of our case today as a civil case, we won't be under any kind of burden if we get arrested on another charge. Whereas if they were out on bail or something, that bail could be revoked and they could be held for 60 days in custody. So it was a way of kind of getting rid of that case and being free to do something else again.
You can say that in Boston, sort of similar deals have been offered to people where where they've been charged with trespassing and then it's been reduced to some type of civil infraction. And some people have taken it and some people haven't. And I think that's a tactical decision within the movement of what people want to do.
Tonight the police came by and told these folks, you have 5 minutes to leave the grass. Now, there's no signs posted anywhere saying you're not allowed to be here. The cops just came up and kind of arbitrarily said to them, we are giving you 5 minutes. That's your notice that you have to leave the grass. So they asked everybody to move off the grass onto the sidewalk. And they said, you can stay on the sidewalk. So that's what they're doing. But we're wondering legally kind of what's wrong with them being on the grass.
I mean, I guess the way it was articulated was that the grass is city property and they don't want them on the grass, but
the sidewalk
is city property too. So there's sort of, it's unclear what the distinction is, what this line between the grass and the sidewalk distinguishes, except that one is significantly more comfortable than the other.
If it's a criminal charge, it's on your record. Well, if the state reduces it to a civil infraction, it won't show up on your criminal record. Well, the charge itself may show up and it may be recorded as reduced to a civil infraction. It depends. If the application says, were you ever arrested, and you were arrested, you have to say yes. But if it says, were you ever convicted, and you were found responsible for a civil infraction, you can say no.
But just a big props to another movement, which is the criminal record reform movement that's been successful in Massachusetts. That question is actually no longer allowed on an application in the state of Massachusetts. They can still ask it to you in an interview, but so that's just my props to a really successful movement that's happened here.